Hey everybody, good evening. Good evening. Today we are going to see into the RTP 2021 November exam of CA Inter, that is of law. The November exam as it is postponed to the December now, December exam. So basically it will be for the December exam now. And we'll be looking at that in some time. Okay, just a second. Now let's understand the matter. Now, before that, just to tell you about the iconic program of Unacademy. You can see here it's a flagship program for CA intermediate aspirants, and you get a live mentoring platform, that is LMP, which is coming soon, where you get one-to-one personal coaching, one-to-one doubt solving, evaluated test series, printed books, industry expert session, and Discord. You can see below each and every area, that is one-to-one personal coaching. You will get strategy sessions on LMP regarding how you should go about your study. This is hugely beneficial for your performance. Then you have one-to-one doubt solving, that is doubt solving sessions on the live mentoring platform, that is LMP. And evaluated test series, test series for every exam attempt, which I'll be telling you soon. And printed books, that is physical books from top educators and Yashas Academy. And industry expert sessions, that is get career insights from top CA professionals. And then of course you have the Discord, that is community building platform, where you get to know regarding your peer CA. Then you have live classes, weekly tests, study material, unlimited access. That is, you can watch the lectures as many times as you want, and you have structured course. Okay, these are the benefits of it. In one-to-one live mentoring in Iconic, you will be getting you can give your live exam prep an extra edge with our new live mentoring program, that is LMP. You can experience personalized learning like never before with our seasoned mentors and doubt solvers. You can discuss your doubts, clarify your concepts, and enhance your exam strategy. Just a click. Get customized study plan from dedicated mentors, and finally, articleship guidance to help you leave your mark in the profession. Okay. You can have evaluated test series. Test series are there in a proper structured manner. You can give your exam prep an extra edge with our latest edition in Iconic subscription. 40% a three-stage test series for every attempt, 80% live tests on 40%, 80%, and 100% of the syllabus completion, and 100% gauge your preparation and exam readiness with our latest tests, followed by analysis classes and detailed evaluation of answers by subject matter experts, and get personal guidance and feedback from experts basis your performance. Iconic subscription, CA Intermediate, use the code Yashas Live. You can see the price there. For 12-month subscription, you have to pay 3188 per month, which is at a 36% discount. And for 24-month subscription, you can see you have to pay only 2750 per month. That is a discounted amount. That is after 33%. Okay, so you can use the code Yashas Live and get maximum benefit. We also have the Unacademy Combat, which will help you to gain your scholarship. So that is a mega combat, which is there on 26th of September at 12 noon. Ensure that you're enrolling on it. You can download the Unacademy app, and then you can go for this mega combat session. It is a CA intermediate notes and scholarships you'll get. That is, you can get free coaching, free notes. The target is for December for 2022 and 2023 exams. Scholarship pool is worth rupees 1 crore plus, and it is on 26 September from 12 noon onwards. Enroll now for free. You have to simply go and download the app. Okay, very simple, very easy to understand. Okay, that is in relation to your Unacademy areas. Okay, now let's start with our okay. Let's start with our CA Inter audit by me, Professor CA Kartik Iyer. Sorry, this will be CA Inter law by mistake. This is been given. Actually, yesterday I had conducted a session on CA Inter audit, and that same has been by mistake copied here. Okay, so we are looking at the CA Inter law RTP. Okay, let's go for it. Now, first we have the case study based question, that is the MCQ. Let's see. That is, Ramesh started a new venture of online business of supply of grocery items at the doorstep of consumers. Initially, it was having the area of operation of Jaipur city only. he employed some young boys having their own bikes and allocated the areas which they were accustomed of it. Basically, the areas which they knew for making delivery of the grocery items as per their orders. So, okay, so he's in the business of delivering grocery items to online business. He also got developed a website and mobile app to receive the orders online. That is a good feature to provide. His friend Sudhanshu, who is a chartered accountant, suggested him to corporatize this business uh, firm from a proprietorship business to a one-person company. So he wants to convert the business from proprietary to OPC. Ramesh agreed, and OPC was incorporated in the name of Ask Ramesh for Online Grocery OPC Private Limited. Now this will be called as OPC 1. Okay. In this OPC Ramesh, Ramesh became the member and director, and Sudha, the mother of Ramesh, was made as no. Okay. Like they have said, after a year, Ramesh got married with Rachana. Since the business of online supply of grocery was on rising trend day by day, he thought of to start a new business of supply of milk and milk products and another OPC, one person company in the name of Rachna Milk Products OPC Private Limited. For short, OPC, this will be called as OPC2, was incorporated with the help of his professional friend Sudhanshu. We had seen here before that Sudhanshu is a chartered accountant. Okay. Then they have given in this OPC2, Rachana, his wife, became the member and director, and Ramesh was named as the nominee. Yes, that is what they have said. Ramesh was named as a nominee. Okay. So to summarize the position, the information is tabulated as under. So they have also summarized the information for you, and they have said name of OPC, ask Ramesh for online grocery, OPC Private Limited, OPC 1, and Rachana Milk Products, OPC Private Limited, OPC 2. So here they have said that member and director in case of OPC 1 was Ramesh, and the nominee in OPC 1 is Miss Sudha, that is the mother of Ramesh. And in the case of Rachana Milk Products, OPC Private Limited, that is OPC 2, the member and director is Rachana, and nominee is Ramesh, that is the husband of Rachana. Okay, so Ramesh is already a member and a nominee. Okay, he's a member in his own OPC, and he's a nominee in another OPC. Now they have written here after some time, Sudha, the mother of Ramesh, passed away. However, before the death, Sudha had made a will, okay, in which she mentioned that after her demise, her another son Suresh will be made the nominee of OPC. She said that after her demise, the nominee of OPC 1 will be. When Suresh came to know this fact, he argued with Ramesh to fulfill the wish of Sudha as per her will. So Sudha here, Suresh has become a little greedy. He wants to become the nominee of one person company so that he'll have some power. Okay, to fulfill the wish of Sudha as per her will, mother of Ramesh and Suresh. But Ramesh denied this and appointed Rachana, his wife, as the nominee. Okay, agreed from the decision of Ramesh for not nominating him, that is Suresh. Suresh threatened Ramesh to take appropriate legal action against him for not honoring the will of Mother Sudha and consulted his lawyer. Meanwhile, due to continuous threatening and hot talks between Suresh and Ramesh, Rachana became mentally upset and became insane. She went mad, as certified by a medical doctor. So lost her capacity to contract. Okay, serious. It seems like a very Hindi, Bollywood movie. Okay, very dramatic. In this situation, Ramesh, being the nominee in OPC 2, became member and director of this OPC. That is what they have given. One of the friends of Ramesh advised him to do some charitable work of providing free education to the girl children of his native village nearby Jaipur. Ramesh thought about this proposal and asked his professional friend Sudhanshu to convert this OPC to Section 8 company. Okay. Based on the above facts, answer the following MCQs. They have given the MCQs below, so let's look at each one of the MCQs. First, they have said, since Rachana, being insane, lost the capacity to contract, Ramesh, who was a nominee, became the member of OPC automatically. Correct? They have said here, now, who will make a nomination for this OPC? That is what they have given. So here, let's see what the answer will be. They have given the option here. Ramesh, in the capacity of husband of Rachana, can nominate any person as nominee of OPC because Ramesh has automatically become the member here. Okay. But they have said here that because in the capacity of husband of Rachana, so they have given a legal right to it. because he's the husband, so he'll get the right to nominate. Okay, so this doesn't seem a completely right answer, but let's wait. Ramesh was nominee of OPC, has now become member of this OPC. It is true. And now, as a member of this OPC, he can nominate any person as per his choice as nominee for this OPC. Now, because now he has become the member, can he appoint his own nominee? He definitely has the power. So, till now, option number B seems to be the right option. When no person is nominated, the central government will make nomination of such OPC2. This is never ever given. It is not there in the Act. When no person is nominated, the registrar shall order the company to be wound up. This is also nowhere given. Okay. So here they have said in this case that the answer will be option number B. That Ramesh was a nominee who has now become a member of this OPC, and now as a member of this OPC, he can nominate any person as per his choice as nominee of this one person. Very clear. So the option in this case is option number B. Next question: whether conversion of OPC2 into a company governed by Section 8 is permissible. Options are: yes, OPC can be converted into Section 8 company. No, OPC cannot be converted into a Section 8 company. This OPC2 can be converted into Section 8 company provided central government gives license. Providing of free education to girl child do not come under the specified objects mentioned for eligibility incorporation of Section 8 company. In this case, it is clearly written, if you read the provisions in relation to the one-person company, it is clearly given that one-person company cannot convert into a Section 8 company, but it can convert into a public or a private company. So here, option number B seems to be the right option. Okay. So here the answer will be option number B. Okay. Let's go to the next one. Amit is the member of OPC1 and became a member in another OPC2 on 2nd April 2020 by virtue of his being a nominee in that OPC. Ramesh shall, by what date, meet the eligible criteria that an individual can be a member in only one OPC. So here they clearly said that if you are a member of one OPC, and because of virtue of law, you have become a member of another OPC. So you are now a member of two OPCs. Actually, not allowed. So they have said here that see, if you have now, if Rachana has become insane and now Ramesh is now the member of OPC2 as well. So he is now the member of two OPCs. He has to take a decision now within 180 days regarding which OPC he should go. Okay. So you can see here that he became member in another OPC, that is OPC2, on 2nd of April 2000. So from 2nd of April 2020, you have to calculate 180 days. So let's calculate together. I have done the calculation here for you, so it is helpful for you. So for April, you have to see how many days are pending. So I'll do 30 days of April minus 2 days, which has already gone by. 2nd April, correct? 30 minus 2, you will get April 28 days. You can see here 828. Then May 31 days, June 30 days, July 31 days, August 31 days. And then to complete 180 days, you will have to see what is the balancing number. The number comes to 29. That is September 29 days. Okay. So by this day, Ramesh should decide which OPC he is going to be a member of. Okay. The answer in this case seems to be option number D. That is 29 September 2020. That is option number D there. Okay. Very, very simple, very easy. Hopefully the calculation is helpful for you. Okay. Next, after the demise of Sudha, the mother of Ramesh, Rachana was nominated by Ramesh for OPC1 as no. But now Rachana has become insane. So what recourse you will suggest to? In this case, Rachana was nominated by Ramesh as OPC1 nominee. Now the nominee position is empty. Okay. So let's see what options they have given. Ramesh is required to nominate another person as nominee. Okay. Ramesh should wait till Rachana becomes good for her health and able to have the capacity to contract. Now Ramesh keeps waiting and you will never know when she will regain back her sanity. So then it will be mistake, because then Ramesh does not have a nominee. The third option you have, although Rachana has become insane, but if she is able to sign her nomination in OPC1, may continue. But the point is that how can Rachana sign, because she is unable to enter into a contract, correct? Because she's insane. Sudhanshu, the child accountant who helped in incorporation of OPC1, may act as legal consultant of Rachana. That depends on whatever deal Rachana and Sudhanshu are having in terms of whether Rachana is appointed Sudhanshu as a legal consultant. Here, option number A seems to be the most correct answer, where Ramesh is required to nominate another person. That is option number 8 in this case. Very clear, very simple. Next, you have another case study. Let's see this case study very carefully. This case study is a big one, so you have to analyze the case in a very, very careful manner. Okay, so let's look at this area. Here they have said Ronak and Bhomik are brothers. They are engaged in the business of dairy. Ronak is having 10 cows. The monthly revenue and expenses of the cows is calculated as under. They are given the calculation below. Revenue is 25 liters per cow per day. That of 10 cows. Sale price multiplied by 40 per liter, 30 days a month. So that comes to 3. Okay. So simply 25 into 10 into 40 and then into 3. That is what I think they have done. They have reached the figure of expenses they have given for feeding 300 cows per day into 10 cows into 30 days in a month. That is 90,000 rupees. Medical expenses, salary to a veterinary doctor per month 10,000. Labor salary 2 persons who are working to feed the cows or to milk the cows. So that is 2% 10,000, that is 20,000. And petrol expenses for milk delivery van lump sum is 10,000 rupees. Total expenses they are given 90,000 plus 10,000 plus 20,000 plus 10,000, that is 1,30,000. That is, you can see that 1,30,000. Okay. Further, they have said here savings per month is 1,70,000, that is simple 3 lakhs minus 1,30,000. And they are given the question 1,70,000. And this, if you earn for 12 months, that is 20,40,000. Salary to Bomik is for looking on its dairy business is 10,000 into 12, that is 1,20,000. And less contingency expenditure 20,000. You will get that the total revenue to be collected after the year is 19 lakhs. Okay. Now they have written the case study here, and this is the Ronak's son Chirag is doing engineering in dairy science from Denmark. And just for knowledge purpose, just want to tell you that Denmark is considered to be one of the largest producers of milk in the world. So in this case, engineering in dairy science from Denmark he's doing, and is in the final year. He learned a lot by his engineering education and want to invite his father to know the technical aspects of dairy business. Chirag insisted his parents to come to Denmark and stay for a year to learn the nitty-gritty, that is the small details of dairy business. Also enjoy the life in traveling nearby area. Ronak talked to his brother Bhomik, explained his plan to visit Denmark for a year and requested to take care of his cow. The laborers are engaged for the maintenance of cows and delivery of the milk. And Bhomik is just to have a watch over it, collect the revenues, etc. That is basically a kind of a supervision, a person who will just supervise everything. Okay. Then they have said here, and take care of the cows till he returns back from Denmark. Ronak also offered Bhomik that for taking care of his dairy business, will pay him rupees 10,000 per month. Ronak also told Bhomik that the cows are covered under the insurance policy, okay, for which he has already paid advance premium and also shared the insurance policy with Bhomik. However, Ronak did not disclose that one cow is under sick. It very often falls sick and needs to be taken care. Bhomik agreed and the cows were shifted. Bhomik's dairy farmhouse. Okay, so Bhomik has agreed to this, what do you call, situation. Ronak and his wife went to Denmark to stay with their son and to understand the dairy business there and to visit the near places. Bhomik was now looking after the dairy business of Ronak along with his dairy business. During the year, cows gave the birth to two cows, okay, two calves. One cow, which often used to fall ill, had also influenced the other cows. As a result, one cow of Bhomik and one cow of Ronak, which remained in close contact with this sick cow, also fell sick. All the three cows, that is two cows of Ronak in total and one cow of Bhomik, died. When the insurance claim was low, the insurance company refused to pass on the claim on the following reasons. They said that one cow of Ronak, which was running sick, was not insured. Postmortem report of another two cows, one of Ronak and another of Bhomik, revealed that these cows were in close touch of the sick cow, and due to infections, these two cows also died. When Ronak returned back to India, he demanded his cows back. Bhomik returned 8 cows, that is 10 minus 2, that is 2 which passed away, but did not return the calves. He said that the calves he will not give because it will act as a compensation to the cows that have died. Bhomik informed Ronak that due to one sick cow of Ronak, his cow also became sick and died, and no insurance claim was admitted. Now they have given the MCQs here. So let's analyze this. They have said here, based on the above facts, answer the following MCQs. Okay. What was the fault on part of Ronak, the bailer in this case? So here they have said Ronak has not taken the insurance policy of the sick cow. Okay. Ronak has not informed the continuous sickness of his cow to Bomik, which is a truthful statement, is a truth. Ronak has left the cows to his brother and went to Denmark to enjoy the traveling and tourism. That is not wrong. Okay, he has properly informed and give it to him. And Ronak, before going to Denmark, should have sold this sick. That is just a suggestion. No. Generally, see in village areas and in India, cows are very much treated as part of the family. So generally, the selling of cow, it may be done, but see, if you go to the rural India, they consider it as a part of their growing up of children and part of the family. Okay. So here they have said, let's see what the option they are giving. They are saying here, Ronak have informed the continuous sickness of his cow to have not informed the continuous sickness of his cow to Bomik. Option number B in this case, the most appropriate answer. Okay, so that is because Ronak has not informed in this. That is the fault on part of Ronak, that is the bailer. If there is anything wrong in relation to what you have given what you have given to the bailee, you have to ensure that you are informing properly whatever is wrong with it. Okay. Let's look at the next one. Here they are given. Can Bomik claim damages for loss of his cow, which died, since the cow remained in the close contact of the sick cow of Ronak? Here they have said, Ronak is not liable for such loss. Bomik should himself take care of his cow. Ronak is liable to pay the price of the deceased cow of Bomik, since this cow died on account of close contact of sick cow of Ronak. And finally, they have said, Bomik should be vigilant in taking care of the cow. Now, you can say here that Bomik can he claim damages for the loss of his cow, which died since this cow remained in close contact with the sick cow of Ronak. So, in this case, you can say here that see, Bomik has been vigilant to the maximum that he could be. He was not informed by Ronak. Okay. So, Bomik should be vigilant, cannot be the right answer. Ronak is not liable, cannot be the right answer. Ronak has to give some kind of compensation. Okay. Then they have said Bomik should take care of his cow. So that is also no, because he cannot control the cow every time. No. Okay. So it seems that option number C here is the right answer. Okay. Ronak is liable to pay the price of the deceased cow of Bomik, since this cow died on account of close contact of a sick cow of Ronak. Okay. So this answer, as you can see, we found the answer by the method of elimination. Okay. Next is whether Bhomik is responsible to give delivery of two calves which took birth during the year when Ronak was on his tour to Denmark. See, whenever let's say I was growing plants at home in the pot and I gave the plant to someone else, okay, to take care. And I told them after I come back I will take the plant from you and I'm giving it to you for taking care of it. Now if the plant bears or flowers, okay, let's say I'm during the lockdown I actually grew small tomatoes and chili in my house. So if I gave that to someone and suppose chilies are growing and in good quantity, and that person use that chili for his purpose, I'll tell you no. When you're returning me the plant, also return the chilies back to me. Okay. So that is exactly basically whenever the baler gives anything to bailee, and whatever is the fruits out of it also should be. So in this case, if the cow has given birth to two cows, those two cows should also be returned. Okay. Let's see the option. Bomik is not bound to delivery of two cows, since he has already lost his own cow due to mistake of not disclosing the sickness of Ronak's cow by him. That is Ronak. That doesn't seem to be the answer because they have said Bomik is not bound to deliver the cow. Bomik is duty bound to hand over the delivery of two cows. This seems to be the right answer till now. Ronak should not insist for delivery of the cows. So Ronak should not insist. No, Ronak has the right to insist, so he will insist. Bomik can keep the cows with him as the cows are born when the cows were in Bomik's custody. It is not there in that. Okay, it cannot be seen in that sense. So here it seems that option number B here is the right answer. Yes, we can see that option number B here is the right answer. Very easy. Bomik returns only 8 cows since 2 cows of Ronak died. Whether Ronak is entitled to claim damages for 2. So here they have said Ronak is entitled to claim damages. Ronak is entitled to claim damages only if he can prove that Bomik has not taken care of the cows as a prudent person, has not taken medical help of the doctor. They have said that if Bhomik has taken proper care of the cows as much as he can, and still if the cows died, then how can you blame Bhomik? He tried his best. Okay, Bhomik should morally pay the loss of cows to his brother Ronak. And finally, Bhomik should not claim his salary since Ronak has already suffered the loss of two cows. Okay, so in this case, it seems that answer number B seems the right answer. Okay, that seems to be the most appropriate answer in this. Let's look at the next area. A Limited made a public issue of debentures. The articles of the company authorizes the payment of underwriting commission at 2%. Now we have shifted the chapter now because the case study chapters are done. They have said that A Limited made a public issue of debentures. So remember debentures here. The articles of the company authorizes the payment of underwriting commission. Okay, so it is in relation to underwriting commission at 2%. So article says underwriting commission of 2% in relation to debentures. Then they have said the company has negotiated and proposed the underwriters, Gamma brokers, and has finalized the rate at 2.25%. The amount that the company is eligible to pay as underwriting commission is should always be AOA or what has the company decided to give, that is 2.5%. Okay, it cannot be given. You have to see always see whichever is lower. So in this case it will be 2%, whichever is lower. Okay. So in this case option number B here is the right option. That is option number B. Because AOA gives a lower percentage. That is why. As a Krishna Religious Publishers Limited has received application of 20 lakhs, that is 2 lakh shares into 10 each, on 10th October 2019. The applicants who applied for allotment of shares in response to a private placement offer of securities made by the company select the latest date by which the company must allow the shares against the application money. So you can see here that the application money is in this received on 10th October 2019. Now, if the allotment of the shares is not done within 60 days from the date on which the application money is received, then you have to refund the money. So the date that you have asked is select the latest date by which the company must allot the shares against the application money. So that is basically we have to calculate 10th October plus 60 days. It is a simple thing, and we have to if we don't allot the shares in that much time, then you have to refund the money that we received as application. Let's see this area. Here they have said so October 10th. So you'll always take 31st October, that is the days in October minus how many days have already got completed in October. That is 10. So you'll take 31 minus 10, that is 21. Then you have 30 days of November and then 9 days of December. Only then you will reach 60. So you have December 9th here. So it seems that option number C here is the right answer. Okay, that is option number C. Okay, very easy. I hope you are able to understand how we are calculating this area. Next, they have said such shares which are issued by a company to its directors or employees at a discount or for consideration other than cash for working or extraordinary hard and achieving desired output is honored with what kind of a benefit? Generally, for hard work, we give something called as sweat equity share. Okay, so that seems to be the right answer in this. That is sweat equity share. Number C. Easy, very covered, very easily covered. Okay. Now, if you have the notes of this area, what I request you all is to go through this part, or if you have the RTP, just go through this area, see whether you have understood it. Pause the video, and then you can play. Okay. Also, please take a small break of just 5 minutes so that you feel fresh and you're joining me. Okay, please do the needful. Okay, now let's continue with this area. Let's see what is there ahead. Here they are given the descriptive questions. Okay, so let's see one descriptive question here and let's analyze the case study. Here they have said in case of company law they have covered first, and here they are given the board of directors of Gen X Fashions Limited at its meeting recommended a dividend on its paid up equity share capital, which was later on approved by the shareholders at the annual general meeting. Thereafter, the directors at another meeting of the board passed a board resolution for diverting the total dividend to be paid to the shareholders for purchase of certain short-term investments in the name of the company. As a result, dividend was paid to shareholders after 45 days. Examining the provisions of the Companies Act 2013 state whether the Act of Directors is in violation of the provisions of the Act, and if so, state the consequences that shall follow for the above violative act. That is what they have said. We can clearly see in this question, they have said that there is a public company and this company has recommended a dividend on its paid up equity share capital. They have said here that the directors at another meeting of the board passed a board resolution for diverting the total dividend to be paid to the shareholders for the purchase of some short-term investment. They thought that they'll get benefit if they transfer the money. But then they have written here, as a result, the dividend was paid to the shareholders after 45 days. If you remember section number 123 clearly, we are required to pay the dividend within how many days? We are required to pay the dividend within 30 days from the date of declaration of dividend. And the dividend should be kept in a separate bank account within how many days? Within 5 days from the declaration. So now what they have said is that we have paid after 45 days. Also, if you don't pay the dividend within 30 days, it has further said that within 7 days, you have to transfer this dividend amount to an account called as unpaid dividend account. So if you are not paying within 30 days, then within the next 7 days, you are required to transfer the dividend amount to an account called as the unpaid dividend account. That is what you are required to do. But if you are unable to do this also, then it's a big problem because then you have violated the condition. So let's see what the law says. According to section number 124, that is the dividend payment should be done in 13 days is 30 days is part of 123, and this within 7 days you have to transfer to unpaid dividend account is covered in 124. Okay, here they have said according to section number 124 of the Companies Act, where a dividend has been declared by a company but has not been paid or claimed within 30 days from the date of the declaration, the company shall within 7 days from the date of expiry of the said period of 30 days transfer a total amount of dividend which remains unpaid or unclaimed to a special account to be opened by the company in any scheduled bank to be called the unpaid dividend account. They have clearly said it will be called as the unpaid dividend account. Further, according to section 127 of the Companies Act 2013, where a dividend has been declared by a company but has not been paid or the warrant in respect thereof has not been posted within 30 days from the date of the declaration to any entitled shareholder, every director of the company shall, if he is knowingly a party to the default, be liable to. So, if it has after declaring the dividend, if it is not paid within 30 days, then a penalty is under section 127. And there they have said every director of the company, if he is knowingly a party to the default, be liable to what punishment. They have further said, in the present case, the board of directors of Gen X Fashions Limited at its meeting recommended a dividend on its paid up equity share capital, which was later on approved by the shareholders at the annual general meeting. Thereafter, the directors at another meeting of the board decided by passing a board resolution for diverting the total dividend to be paid to the shareholders for purchase of certain short-term investments in the name of the company. As a result, dividend was paid to shareholders after 45 days. You understand that they have just written the application part of the question. So this is a beautiful way of actually writing the answer. First, they have mentioned the provision part. Then they have mentioned the application part, how it affects this question. Then they have given here more This declared dividend has not been paid within 30 days from the date of the declaration to any shareholder entitled to the payment of dividend, the company shall, what will the company do if 30 days, within 30 days we have not paid then? The company shall within the 7 days from the date of expiry of the said period of 30 days transfer a total amount of dividend which remains unpaid or unclaimed to a special account to be opened by the company in any scheduled bank, we called the unpaid dividend account. The board of directors of Genex Fashions Limited has violated Section 127 of the Companies Act 2013 as it failed to pay dividend to shareholders within 30 days due to its decision to divert the total dividend to be paid to shareholders for purchase of certain short-term investments in the name of the company. Now, finally, they have given us the consequences. They have said the following are the consequences for violation of the above provisions. They have written here every director of the company shall, if he is knowingly a party to the default, be liable to a maximum imprisonment of 2 years, and he shall also be liable for a minimum fine, rupees 1,000 for every day during which such default continues. That they have clearly given here. The company shall also be liable to pay simple interest at a rate of 18% per annum during the period for which such default continues. Simple interest has to be paid at 18%. Okay, pretty straightforward answer. This one very, very easy to understand. Okay, I hope it is helpful to you. Next question is the board of directors of Moonlight Limited, a listed company, appointed Mr. Teja, chartered accountant, as its first auditor within 30 days of registration. Now, if I take you to section number 139, what does section 139 say? The appointment of the first auditor of the company, and this I'm specifically looking at subsection number 6. Appointment of the first auditor of a company other than a government company. We are assuming that Moonlight Limited is not a government company. Okay, they've said here it's a listed company. So we'll say that in such a company, the first auditor of the company, has to be appointed by the board of directors within 30 days. Within 30 days from the date of the registration or incorporation of the company. So Mr. Teja, who is a chartered accountant, as it was appointed as the first auditor within 30 days from the date of registration, to till here has the company done everything all right? The answer is yes. I'm just putting a small tick mark here. Of the company to hold office from the date of incorporation to the conclusion of the first AGM. Correct. The appointment of the first auditor is from the date on which he is appointed till the end of the first AGM. Now, what will happen after the end of the first AGM? You will have to appoint another auditor, right? That will be the subsequent auditor. They have written here at the first AGM, Mr. Teja was reappointed to hold office from the conclusion of the first AGM to the conclusion of the sixth AGM. In the light of the provisions of the Companies Act 2013, examine the validity of an appointment or a reappointment in the following cases. Appointment of Mr. Teja by the board of directors. Is this appointment correct or incorrect? The answer will be the appointment, in my opinion, is correct because the board of directors have done nothing wrong. Also, they have said here, see, at the first AGM, Mr. Teja was reappointed to hold office from the conclusion of the first AGM to the conclusion of the sixth AGM. Again, the subsequent auditor can get up to one term of up to 5 years each. Okay, that is maximum up to 5 years. Can it be extended? The answer is yes, but in this case, it's a listed company. Okay, so in such a company, the rotation of auditor principle will be applicable. And in this case, there is no firm appointed. They have just appointed Mr. Teja, who is a proprietor. It seems that he's a proprietor. So you can get one term of up to 5 years each maximum. Okay. And after that, there will be rotation of the auditor, but they have not covered the rotation area in this question. Let's go ahead. So appointment of Mr. Teja by the board of directors, that is appointment of Mr. Teja as the first auditor, is it correct? The answer is yes. Reappointment of Mr. Teja at the first AGM in the above situation. Can Mr. Teja be reappointed to be as a subsequent auditor of the company? The answer is absolutely yes, no issues. The reason being, see, even if Teja was appointed as a first auditor, and let's say this is the date when company was incorporated, and this is the day when the company conducted its first AGM, so he was appointed during this period in the capacity of being the first auditor. Correct. But when he is appointed again, in this case, when he's appointed, he is not acting as the first auditor. His capacity has changed. He is now the subsequent auditor. Now, this auditor will stay in office from the first AGM till the conclusion of the sixth AGM. The conclusion of the sixth AGM. Very clear, very, very simple. The first AGM, second AGM, third AGM, fourth AGM, fifth AGM, and sixth AGM. So that is one term of up to 5 years each he can get, and he's utilizing it completely in a proper manner. And it's in this case, I don't see any violation or any wrongdoing on account of Mr. Let's see this. As per Section 139, subsection 6 of the Companies Act 2013, the first auditor of a company other than a government company shall be appointed by the board of directors within 30 days from the date of registration of the company, and such auditor shall hold office till the conclusion of the first AGM. Whatever the company has done is still now correct. Whereas Section 139, subsection 1 of the Companies Act states that every company shall, at the first AGM, appoint an individual or a firm as an auditor of the company who shall hold office from the conclusion of the first AGM till the conclusion of the sixth AGM, and thereafter to the conclusion of every sixth AGM. That is what they are given here. As per Section 139, subsection 2, no listed company or a company belonging to any such class of company may be prescribed shall appoint or reappoint an individual as auditor for more than one term of 5 consecutive. They are not allowed to appoint. Clear? Then they have said, as per the given provisions, following are the answer that we are looking. Let's look at the answer in this case. They have said, appointment of Mr. Teja by the board of directors is valid as per the provisions of section 139 subsection 6, as I told you. So this seems to be valid. This seems to be. Second is, appointment of Mr. Teja at the first AGM is valid. Again, this is correct. Due to the fact that the appointment of the first auditor made by the board is a separate appointment, correct? And the a period of such appointment is not to be considered. Okay. While Mr. Teja is appointed as the first annual general meeting, which is for a period from the conclusion of the first AGM to the conclusion of the sixth. Okay. For students who are unaware about this concept, just telling you that if Mr. Teja is appointed as the auditor, that is subsequent auditor in the first AGM, you will understand that from the first AGM to the second AGM is 1 year. From the second AGM to third AGM is 2 years completed. Third to fourth is 3 years completed. Fourth to fifth is 4 years completed. And fifth to sixth is 5 years completed. You can see here from fifth to sixth AGM, you are completing 5 years. That is, you can see here exactly that this is completely a period of 5 years. Easy to understand, very, very easy, very comfortable. Okay, no problem at all. That is in relation to this part. Next, I said Kim Private Limited was incorporated on 30th September 2000. It has a paid up share capital of 45 crores. The company had a turnover of 250 crores for the financial year 2019-20. The accounts manager of the company intimated to the company that they are not required to appoint internal auditor for the financial year 2021. The management of the company have approached you to advise them about the appointment of internal auditor. This is the question. How do you go about and solve such a question? To understand, see, we want to appoint the internal auditor for the year 2020, correct? So whenever we want to appoint the internal auditor for 2020-21, we will directly look at the previous year, right, 2019-20, 2019-20, and we look at the figures for that particular year. Now, generally, if I give the limits for all companies, I do a code called as LOPOT. Then you have 25, 50, 100, 200. That is the code. Okay, LOPOT 25, 50, 100, 200. What is all these areas? Listed company has to compulsorily appoint an internal auditor. So if I'm looking at 2021 and if at 2020-21, if it's a listed company, I have to appoint the internal auditor compulsorily. Then if now we are looking at 2019-20 year, if at any point of time in 2019-20, remember the words at any point of time in 2019-20, if there are outstanding deposits of 25 crores or more, or in the year 1920 at the year end, that is 31st March 2020, if the outstanding paid capital is 50 crores or more, if the outstanding loans or borrowings from public deposit or banks is more than 100 crores, This is at any point of time during the year, that is 1920. And finally, the company's turnover is 200 crore rupees or more in the financial year 2019-20. Now, all these conditions are OR conditions. Or So even if one condition is satisfied, we will appoint the internal auditor. But what I've given you here is this is in relation to what I've given you here is this is in relation to unlisted public company. But you can see here, this is Kim Private Limited. That is, you have a private company here, private limited company here. So in the case if it is a private company, you have to only look at these two conditions which are there at the end. With these two conditions which I'm boxing. So let's see. They have said here the paid up share capital of the company is 45 crores. We have nothing to do with the paid up share capital of the company. Nothing to do. They said the company had a turnover of 250 crores during the financial year 1920. So they have clearly said that in this case the turnover was how much? 250 crores. So now because the turnover is 250 crores, we'll say that this case the appointment of internal auditor becomes compulsory for Kim Private Limited, especially when they are in 2020-21. Because in 1920, that is the previous year, you can clearly see that the turnover figure has been breached. I hope it is very easy to understand. Okay, now this is your section number 138 of the Companies Act 2013. Okay, let's look at the next area. Let's look at the answer, how they have presented it. According to section 138, along with rules of Companies Act 2013, every private company having a turnover of 200 crore rupees or more during the preceding financial year, or outstanding loans or borrowings from banks or public financial institution, that is your LB from PB, okay, loans or borrowings from public financial institution or banks exceeding 100 crore rupees or more at any point of time during the preceding financial year, okay, shall be required to appoint an internal auditor, which may be either an auditor, an individual, or a partnership firm, or a body corporate. That is what they are clearly mentioned. In the given question, the company has a paid up share capital of 45 crores and turnover of 250 crores for the financial year 2019-20. The company is fulfilling the criteria of turnover as we said, that is, it is more than 200 crores because it is 250 crores. Here, hence, it is required to appoint internal auditor for the financial year 1920. Okay, very simple, very easy, very manageable. Okay, that is your point number. That is your answer number 3. Next question that given here is define the term charge and also explain what is the punishment for default with respect to registration of charges as per the provisions of the Companies Act 2013. Okay, registration of charges, as you know, is chapter number 6 of the Companies Act. They have said here the term charge has been defined in section 2, subsection 16 of the Companies Act 2013 as an interest or lien created on the property or assets of a company or any of its undertaking, or both as security and includes a mortgage. Okay. What is the punishment for contravention? According to section number 86 of the Companies Act 2013, if any company is in default in complying with any of the provisions of this chapter, the company shall be liable to a penalty of 5 lakh rupees, and every officer of the company who is in default shall be liable to a penalty of 50,000. Very easy, very simple. So they're given the penalty. Penalty, what I've seen is it is generally a slightly difficult affair for the student because there's so many penalties in the companies. What we have done is on Unacademy in the app, when you go to the app, you will see that a special session on penalties and form number has been taken. In that, because of time constraint, I could only cover the penalty area, but the form number sheet is also present there. You can simply go there and download it. Okay, that will be available on Unacademy platform. Take the given here. Further, if any person willfully furnishes any false or incorrect information or knowingly suppresses any material information which is required to be registered under section 77, he shall be liable for action under section 447. Okay, 447. Easy to understand till here. Okay, very manageable, very easy. Okay, let's see this. Yellow Private Limited is an unlisted company incorporated in the year 2012. The company have a share capital of rupees 50 crores. The company has decided to issue straight equity share, that is for the hard work, to its directors and employees. The company decided to issue 10% straight equity, which in total will add up to 30% of its paid up share capital. Okay, so 10% shares have been given as straight equity with a locking period of 5 years. They have said that a locking period in this case will be how many years? 5 years. As it is a startup, it is only a startup. How do you justify these facts in relation to the provision for issue of sweat equity shares by a startup company with reference to the provision of the Companies Act 2013? They have written the word here explain. You have to explain this area. So here you can see here in relation to sweat equity shares, there are two rules here, very, very important. Rule 8 sub rule 4 and rule 8 sub rule 5. Now let's understand the provision which is with the base section, that is 54. Sweat equity shares is governed by section 54 of the Companies Act 2013 and rule 8 of the Companies the Share Capital and Debentures Rule 2014. According to section number 54, the company can issue sweat equity shares to its directors and permanent employees of the company. According to rule 8 sub rule 4, whenever there is something written in bracket after rule, you have to read as sub rule. Whenever there is written something in bracket after section, you have to read as the subsection. But mostly it will be subsection. Sometimes clause are also directly written, but that is in it is seen in the act called SCRA, Securities Contract Regulation Act. In these acts, they directly write the clause number. But generally, we see if it is a number, if it is a numerical, like for example, you see 4, it is a subsection. According to rule 8, in this case, because it is a rule, it will be sub rule. If it would have been section, they would have said section 8, subsection 4. Okay, but it is rule sub rule 4. Proviso states that startup company is defined in the notification number, Ministry of Corporate Affairs and Industry, Government of India, may issue sweat equity share. So that notification number here is not covered, it is missing in this case. As said here, equity shares not exceeding 50,000 of its paid up share capital up to 10 years from the date of its incorporation or registration. So it can be not exceeding 50% of the paid up share capital up to 10 years from the date of its incorporation or registration. That is what they have given here. Okay. Next they are given. So this is in the case of startup company. Next they are given according to rule 8 sub rule 5. The sweat equity shares issued to directors or employees shall be locked in or non-transferable for a period of 3 years from the date of allotment and the fact that the share certificates are under lock-in 2. That is what they have said here. So basically you can understand that see we have given a sweat equity of 10% and our lock-in in this case is how many years? 5 years. What they have said is up to 50% you can give, but lock-in should not be 5 years, it should be 10 years ideally. So let's see the conclusion, what conclusion they have drawn. Okay, sorry, lock-in, I'm very sorry, not 10 years. They have said that lock-in, this, what do you call, the sweat equity should not exceed 50%. And this is applicable for 10 years, that it should not exceed 50%. Okay. Lock-in in this case, they have said in this rule, that is 3 years. Now, in this case, the lock-in we have put more stricter, we have given 5 years. So that will be incorrect. So let's see this. Hence, in the above case, the company can issue sweat equity shares by passing a special resolution at its general meeting. The company, as a startup company, is right in issue of 10% sweat equity shares as it is overall within the limit of 50% of the paid up share capital. But the lock-in period of the shares is limited to maximum 3 years period of the date of allotment. That is what they have clearly given. Okay, very, very simple, very easy to crack and easy to understand. Okay, I hope you are finding it useful. AB Limited issued equity shares of 1 lakh, 10,000 shares of rupees 10 each on 1/4/2020, which have been fully subscribed, whereby XY Limited holds 4,000 shares and PQ Limited holds 2,000 shares in AB Limited. AB Limited is also holding 20% equity shares of RS Limited before the date of issue of equity shares stated above. RS Limited controls the composition of the board of directors of XY Limited and PQ Limited on 1/8/2020. Examine with the relevant provisions of the Companies Act 2013. That is what the question is. Now, what you will do here is you will have to first, whenever such a question is given, always try to frame a diagram. Okay, that makes your understanding much more clearer. Okay. So here they have said AB Limited issued equity shares of 1 lakh on 1/4/2020, which have been fully subscribed, whereby XY Limited holds 4,000 shares and PQ Limited holds 1,000 shares. You understand here that there is a company called as AB Limited, and AB Limited in this case has 10,000 shares. Now they have said here that out of these 10,000 shares, XY Limited in this case holds 4,000 shares. And they have said PQ Limited in this case holds 2000 shares. Clear? Very, very simple. Now they have further said, so understand this point now, very, very important. They have said that, see, there is another company called as RS Limited. They have said AB Limited also is holding 20% shares of RS Limited before the issue of the equity shares. But RS Limited controls the board of directors of XY Limited and PQ Limited. So in this case, you can say that RS Limited is holding this company. That is, RS Limited in this case is holding or is having control over XY Limited and PQ Limited. That is RS Limited. That is not by equity shares. That is by controlling the board of directors. Now, how do you control the board of directors? Let's say that RS Limited in this case has 11 directors. Okay, it is possible that if say XY Limited has 5 directors, out of 5 directors, 3 directors have been sent from RS Limited. So all the decision making power is with the RS Limited in relation to XY Limited because it has majority of the board of directors in XY Limited. Similarly, let's say that in this case PQ Limited, there are let's say 8 directors, and out of 8 directors, 5 directors are coming from RS Limited. So you understand that in this case, you are also having control over PQ Limited. That is the situation in this case. Now, to add to the twist, they have said, and they have said here in this line, AB Limited is holding 20% shares of RS Limited. So in this case, you can see AB Limited is holding 20% shares in the reverse way in RS Limited. 20% AB Limited is holding. Now, of course, when you see the subsidiary holding shares in the holding company, this is directly, the provision that will be applicable is in relation to section number 19, where it clearly says subsidiaries should not hold shares in the holding company. Okay. But now let's analyze the provision and let's see. And they have clearly said here, see, AB Limited was holding these many shares before the date of issue of equity shares. So before AB Limited issued equity shares to XY Limited and PQ Limited, it was already holding shares before that. What does the provision of section 19 say? Look at that. First, they're asking you the question whether AB Limited is a subsidiary of XY Limited. Whether AB Limited is a subsidiary of what? XY Limited. That is the first question that they're asking. Okay. Now, for looking at the definition of subsidiary, we look at section number 2, subsection 87. And whether AB Limited can hold the shares in RS Limited, that will be dealt with section number 19. Okay. Then you have whether AB Limited can vote at the AGM of RS Limited held on 13/9/2020. That is again covered in section number 9. Okay, so I hope it is very, very understandable for you. Okay, let's see. The given problem is based on subclause 87 of clause 2 read with section number 19 of the Companies Act 2013. As per subclause 87 of clause 2 of the Companies Act 2013, subsidiary company A or subsidiary in relation to any other company, that is a holding company, means a company in which the holding company controls the composition of the board of directors or exercises the controls of more than 1/2, means 50%. So it is holding 50% of the total voting power either at its own or together with one or more of its subsidiary companies. You can see here it either controls the composition or controls more than 1/2 of the total voting power either at its own or together with one or more of the subsidiary companies. That is the matter here. For the purposes of this clause, explanation is given providing that a company shall be deemed to be a subsidiary company of the holding company even if the control referred to in point number 1 or point number 2 above is of another subsidiary company of the holding company. They have said that a company shall be deemed to be the subsidiary company of the holding company even if control referred to in point number 1 and point number 2 above is of another subsidiary company of the holding company. So they are saying that even if it is an interlinked transaction, still they are saying that it is still allowed. So here in this case it makes sense because in this case AB Limited is controlled not by RS Limited directly but by XY Limited and by PQ Limited, and that is why RS Limited is indirectly having a control on AB Limited. Now they have said, so basically is it a subsidiary company? The answer is yes. The answer is yes. It deemed to be a subsidiary company. Next, whereas Section 19 provides that no company shall hold any shares in its holding company, and no holding company shall allot or transfer its shares to any of its subsidiary companies, and any such allotment or transfer of shares of a company to its subsidiary shall be void. That is what they have said. But then they have provided certain exceptions. Okay, so we'll be looking at the exceptions also very, very closely, and we'll look into that area. They have further said, and then one of the exceptions in this case is provided that nothing in this subsection shall apply to a case where the subsidiary company is a shareholder even before it became the subsidiary company of the holding company. So that is, in one way, the subsidiary company will be allowed to keep its shares with it. Okay, it will not be declared as void. So then they have said, here in the incident case, AB Limited issued 10,000 equity shares of on 1/4/2020, whereby XY Limited and PQ Limited holds 4,000 and 2,000 shares respectively in AB Limited. Considering one share is equal to one vote, okay, they have said one share is equal to one vote. They have said here, XY Limited and PQ Limited together holds more than one half of the total voting power. More than one half of the total voting power. Therefore, AB Limited will be subsidiary to XY Limited and PQ Limited on 1/4/2020. Whereas AB Limited is already holding 20% shares of RS Limited before the date of issue of equity shares, that is 1/4/2000. That is what they have said in here. Then they are saying, further, RS Limited controls the composition of the board of directors of XY Limited and PQ Limited from 1/8/2020. Okay, in the light of the subclause 87 of clause 2, RS Limited is a holding company of XY Limited and PQ Limited, that is subsidiary companies. So here you can see that the control is maintained. Now they have now concluded, and let's see the conclusion here. Following are the answers to the questions. Now what have they said here? Yes, in this case, AB Limited shall be deemed to be a subsidiary company of the holding company RS Limited, as RS Limited controls the composition of the subsidiary companies XY Limited and PQ Limited, as per the explanation to subclause 87 of clause 2. Okay. Yes, in this case, AB Limited is a subsidiary of RS Limited, as AB Limited was holding 20% of the equity shares of RS Limited even before it became a subsidiary company of RS Limited, according to the exception, section 19. So in both the cases, they have said yes, AB Limited will be deemed to be a subsidiary company, the holding company. Very clear? Finally, they have said here, no, the subsidiary companies shall have the right to vote. So the last question was whether AB Limited will be having a right to vote at the AGM of RS Limited. In this case, they have said yes, the subsidiary company will. So generally, what happens is, if the subsidiary company is having a share in the holding company, the subsidiary company is not allowed a right to vote. Okay, but in this case, they have said that, see, out of three conditions that are there, in two conditions you are allowed to vote. If one condition you are not allowed to vote, and that is the exact condition that AB Limited is having now. That is where AB Limited was a shareholder even before it became a subsidiary. So in this situation, you will not be having voting right. So let's see this. The subsidiary company shall have a right to vote at the meeting of the holding company only in respect of shares held by a legal representative, that is case number 1, or as a trustee, that is case number 2, but not where the subsidiary company is a shareholder even before it became a subsidiary company of the holding company. Therefore, AB Limited cannot vote at the AGM of RS Limited held on 30/9/2020. That is what they have said in this case. I hope it is very, very easy, very, very simple to understand. Okay, that is in relation to this part. It's a big case study. In the exam, if it comes, it will fetch you 6 marks. To ensure that you are doing this properly, it's a very simple. If you understand with a cool mind and if you do it, you will be able to write the correct answer in the examination. Okay, let's go ahead. Nutty Buddy Limited is manufacturing premium quality milk-based ice cream in 2 flavors, chocolate and butterscotch. The company called its annual general meeting in order to lay down the financial statements for shareholders' approval. However, due to the want of quorum, the meeting was cancelled. Also, the directors of the company did not file the annual return with the registrar. The directors were of the idea that the time for filing of returns within 60 days from the date of the AGM would not apply, as AGM was cancelled. Has the company contravened the provisions of the Companies Act 2013? If the company has contravened the provisions of the Act, how will it be penalized? So that is the question that they have asked in this. Now to understand, see, the company cannot just say that, see, we will not file the annual return just because we have not conducted the AGM. What will happen is, because of the AGM, a lot of other things will also get delayed. So what they have said in law is, see, we have given you time of 60 days file the annual return from the date of the AGM. But let's say you are not giving the AGM. Let's say you are not giving the AGM on time. Then the AGM should be kept. Then the annual return should be filed from the last date when the AGM should have been held. So now, generally, if this is the year Then what is the last date when the AGM should have been held? What is the last date from which the AGM should have been held? That is, let's say this is 1/4/2000 and let's say 20. So the previous year ended on 31st March 2020, correct? So 6 months from this date will be 30th of September 2020. So this is the last date when the AGM should have been held. Now, if the AGM is not held by this day also, then they've said within 60 days from this day, the annual return has to be filed with the ROC. If the annual return is not filed with the ROC along with the reasons that why the AGM was not conducted, if you are not filing that, then the company will be penalized. So there will be contravention of the provisions. Okay. So let's understand and see how this case study goes. Here they have written that according to section number 92, subsection number 4 of the Companies Act 2013, every company shall file with the registrar a copy of the annual return within 60 days from the date on which the annual general meeting is held, or where no annual general meeting is held in any year within 60 days from the date on which the annual general meeting should have been held, together with the statement specifying the reasons for not holding the annual general meeting. Then they have said, subsection number 5 of section 92 also states that if the company fails to file the annual return under subsection 4, that is right now which we read, yes, subsection 4, before the expiry of the period specified therein, such company and every officer who is in default shall be liable to a penalty of 10,000 rupees, and in the case of continuing failure, with a further penalty of 100 rupees for each day during which the failure continues, subject to a maximum of 2 lakh rupees in case of a company and 50,000 rupees in the case of an officer in default. So the maximum limit is different for a company, that is 2 lakhs, and for the officer in default, that is OID, it is 50,000 rupees. Very clear. So that is what the provision says. Now then they have said in the instant case, now this is like a concluding part. In the instant case, the idea of the directors that since the AGM was cancelled and the provision requiring the company to file annual return within 60 days from the date of AGM would not apply is incorrect. In the above case, the annual general meeting of Nutty Buddy Limited should have been held within a period of 6 months from the date of closing of the financial year, but it did not take place. Thus, the company has contravened the provisions of section number 92 of the Companies Act 2013 for not filing the annual return and shall attract the penal provisions along with every officer of the company who is in default as specified in section number 92 subsection number 5 of the. Okay, very simple. So that is how they have concluded it in a proper manner. Next, we go to the next area in relation to Companies Act, and let's see this. 500 equity shares of ABC Limited were acquired by Mr. Amit, but the signature of Mr. Manoj, the transferor, on the transfer deed was forged. So here what must have happened is Manoj, running MJ, the transferor, he has sold the shares to Mr. Amit. Okay. Now Mr. Amit in this case were acquired by Amit. So Mr. Amit has purchased the shares. But remember, the shares were not actually signed by Manoj. It was signed by someone else. Okay. So these shares were forged. Okay. And Mr. Amit has already purchased the shares. Mr. Amit, after getting the shares registered by the company in his name, sold 250 equity shares. So out of the 500 equity shares that Amit got, Amit has sold 250 equity shares in this case, and he has sold the same to Mr. Abhi on the strength of the share certificate issued by ABC Limited. So he has the ABC Limited share certificate with him because it is registered with the company, and Amit in this case sold the shares to Abhi. Correct? Then they have said here, they have written here, Mr. Amit and Mr. Abhi were not aware of the forgery. They did not know that the share certificate earlier which Amit had purchased, they were forged. What are the liabilities or rights of Mr. Manoj, Amit, Abhi against the company with reference to the aforesaid shares? So here you can understand. See, currently, if you see, Amit is still holding 250 shares, correct? He had purchased 500 and he sold 250 shares. And Abhi is holding the 250 shares that he purchased from Amit. Okay, so this is the situation. And Manoj in this case did not maybe want to sell the share, but somebody forged these documents of which Manoj had and gave the shares to Amit. So even Manoj is at loss. So if all three are worried, okay, what will happen? So the Companies Act 46 section number, that is this section number 46, it says that according to the Companies Act 2013, a share certificate once issued under the common seal, if any, of the company or signed by two directors or by a director and the company secretary, wherever the company has appointed a company secretary, specifying the shares held by a person, shall be prima facie evidence of the title of the person's person to such shares. So if the person has got a share certificate, it is signed by under the common seal of the company, or if that is not there, then signed by two directors or by a director and the company secretary. Then it is that the person prima facie will say, okay, this person has the title of the shares. Therefore, the normal course, the person named in the share certificate is for all practical purpose. Person named in the share certificate is for all the practical purposes the legal owner of the shares, therein, and the company cannot deny his title to the share. Okay. However, a forged transfer is a nullity. Nullity means we have to again bring back to the zero transaction. That is, again the shares will be given to Manoj. Because when a forged transfer is there, it will be considered as a nullity. It did not give the transferee, Mr. Amit, any title to the shares. Similarly, the transfer made by Amit to Mr. Abhi will not give a good title to the shares, as the title of the buyer is only as good as the title of the seller. So if Amit is not considered to be a buyer in himself, then how can Abhi be a buyer if Abhi is purchasing the shares from Amit? Because Amit in that case will become the seller. So if Amit does not have the shares, how can Abhi have the shares then? Okay, the same shares. Therefore, the company acts on a forced transfer and removes the name of the real owner, Mr. Manoj, from the register of members, then the company is bound to restore the name of Mr. Manoj as the holder of the shares and to pay him any dividend which he ought to have received. Yes, they have said clearly that he is the holder of the very clear. So in the above case, therefore, Mr. Manoj has the right against the company to get the shares recorded in his name. However, neither Mr. Amit nor Abhi have any rights against the company, even if they are bona fide purchasers. But as Mr. Abhi acted in the faith of share certificate issued by the company, he can demand compensation from Mr. Amit. Okay, so that can be taken. Very easy, very simple, easy to understand. Let's look at this one. That is from the Indian Contract Act. It's a very nice case. Okay. Let's see. That is basically in the case where emergency is there, and if you are an agent acting in the case of an emergency. Let's see this. Mr. Yadav, a cargo owner, chartered a vessel to carry a cargo of wheat from a foreign port to Chennai. Okay. So Mr. Yadav, a cargo owner, he took a vessel to carry a cargo of wheat from a foreign port. Yeah. The vessel got stranded on a reef uh, in the sea 300 miles from the destination. Okay, so the vessel got stuck maybe because of the flow of the ocean or something. The ship's managing agents signed a salvage agreement for Mr. Yadav. So the ship's managing agents, so those who are there in the ships, they signed a salvage agreement for Mr. Yadav. The goods, that was wheat, being perishable, the salvors stored it at their own expense. Salvors, what they did is they stored it at their own expense. Salvors intimated the whole incident to the cargo owner. Mr. Yadav refused to reimburse the salvor. He did not reimburse the salvor, as it is the ship owner, being the bailey of the cargo, who was liable to reimburse the salvor until the contract remained unterminated. Referring to the provisions of the Indian Contract Act 1872, do you acknowledge or decline the act of salvor as an agent of necessity for Mr. Yadav? Explain. So now here what has happened is you can clearly see that it is wheat. Wheat is a perishable item. Now in the middle of the reef, you have to see Indian Contract Act is an act where you have to apply common sense, simple common sense. Now if there is a perishable item and you're in the middle of the sea, but there is someone who is who is nearby there, maybe some port is nearby, not the final location, but some port nearby where you can just sell it off so that the perishable item doesn't go stale. Okay, it doesn't become bad. So in this case, a person of normal prudence, what he'll do is he will then sell the item to some person so that he can get at least some money, because if it goes waste, then it is of no value. And then after that, this person will then pay the principal, that see, this amount I'm going to give it to you. So in this case, they have said that Mr. Yadav did not reimburse the salver. So the matter here is in relation to Indian Contract Act section number 189, as you can see. I've said here defines agent's authority in an emergency. An agent has authority in an emergency to do all such acts for the purpose of protecting his principal from loss, as would be done by a person of ordinary prudence in his own case under similar circumstances. In certain circumstances, a person who has been entrusted with another's property may have to incur unauthorized expenses to protect or preserve it, properly. This is called an agency of necessity. That is called an agency of necessity. Hence, in the above case, the salver had implied authority for the cargo owner to take care of the cargo. They acted as agents of necessity on behalf of the cargo owner. Cargo owner were duty bound towards salver. Salver is entitled to recover the agreed sum from Mr. Yadav and not from the ship owner as lien on the goods. Mr. Yadav should be duty bound to reimburse the salver. Next question: Rahul is the owner of electronic shop. Priyanka reached the shop to purchase an air conditioner whose compressor should be of copper. So she wanted a air conditioner which is whose compressor, the part of the air conditioner, should be made of copper. As Priyanka wanted to purchase the air conditioner on credit, Rahul's demand was Rahul demanded a guarantor for such transaction. Now, Mr. Arvind, a friend of Priyanka, came forward and gave the guarantee for payment of air conditioner. You can see Rahul here, you can see Priyanka here, and you can see Arvind here. Okay. Although I don't want to make any political reference, but with these names, you are clearly indicated towards something. Okay. So gave the guarantee for payment of air conditioner. Rahul sold the air conditioner of a particular brand, misrepresenting that it is made of copper, while it is made of aluminium. So he misrepresented. Neither Priyanka nor Arvind had the knowledge of the fact that it is made of aluminium. On being aware of the facts, Priyanka denied for payment of price. Rahul filed a suit against Mr. Arvind, saying that he has to pay me the money, and explained with reference to the Indian Contract 1872 whether Mr. Arvind is liable to pay the price of air conditioner. In this case, the answer will be because Rahul has misrepresented, he has looked to cheat. So in that case, it will be misrepresentation and the payment will not be made to Rahul. It is not required to be made. So as per the provision of section number 142 of the Companies Act 1872, where the guarantee has been obtained by means of misrepresentation made by the creditor, in this case creditor is Rahul, concerning a material part of the transaction, the surety, in this case is Arvind, will be discharged. Further, according to the provision of section number 134, the surety is discharged by any contract between the creditor and the principal debtor, by which the principal debtor is released, or by any act or omission of the creditor, the legal consequence of which is the discharge of the principal debtor. Okay. In the given question, Priyanka wants to purchase air conditioner whose compressor should be of copper on credit from Rahul. Mr. Arvind has given the guarantee for payment of price. Mr. Rahul sold the air conditioner of a particular brand on misrepresenting that it is made of copper, while it is made of what? Aluminium. It is made of aluminium, of which both Priyanka and Mr. Arvind were unaware. They were not aware about this situation. After being aware of the facts, Priyanka denied for payment of price. Rahul filed the suit against Mr. Arvind for payment of price. Okay. On the basis of the above provisions and the facts of the case, as guarantee was obtained by Rahul by misrepresentation of the facts, Mr. Arvind will not be liable. He will be discharged from his liability. That is what they have clearly mentioned. Okay. Now another question is here, that is Akhil made a promissory note in Negotiable Instruments Act. Akhil made a promissory note of 4,500 payable to Bhuvan and delivered the same to Mr. Bhuvan on the condition that he, that is Bhuvan, will demand payment only on the death of Mr. Shaman. They have said here, before the death of Shaman, Bhuvan endorsed and delivered the promissory note to Deepak, who received the promissory note in good faith. So Deepak did not know about all these things, about the condition. On the date of maturity, Deepak presented a promissory note for payment, but Akhil denied for payment by stating that he issued the promissory note on the condition it can only be paid on the death of Shaman. Can Deepak recover the amount due on the promissory note from Akhil under the provision of Special Instruments Act? Deepak is here not at fault. Akhil here made a promissory note based on any condition, and that is why Deepak can recover in this case. So let's see the condition. I'll take you directly to the area so you can read the provision. This is as per the Companies Act, this is as per the Negotiable Instruments Act itself. But here you can see here from the above provision and the facts of the case, it can be said that Deepak has received the promissory note in good faith. He is the holder in due course. So in the end, the money has to come to him. And his rights will not be affected by any condition attached to the instrument by any prior party. Therefore, Deepak can recover the amount due to the promissory note from Akhil. Very clear, very simple. He can recover. Next, General Clauses Act. There is in relation to the grace period part. Mr. Sohan has issued a promissory note of rupees 1,000 to Mr. Mohan on 17th May 2021, payable 3 months after. After that, a sudden holiday was declared on 20th August 2021 due to a festival. As per the provisions of the General Clauses Act 1897, what should be the date of the presentment of promissory note for payment? Whether it should be 19th August or 21st August. That is, you can clearly see, okay, now let's solve it very quickly. 17th May, and if you add 3 months to it, it leads to our 17th of August, correct? 17th May, and this will lead to 17th of August. So we are going from 17th May. 3 months if you add, it will go to 17th of August, plus we have to add 3 days of grace. So you come to 20th of August. But they have clearly said 20th of August is a holiday. And this word is important, sudden holiday. It means that it was not a pre-planned holiday. Okay, it was not announced beforehand. So if it's a sudden holiday, then you understand that we have to go to the next day. And that will be the date. That will be the date. That will be the due. That will be considered as a due date, correct? That is the final date. That is the answer. Let's see this. Section number 10. You will clearly see. After reading the entire thing, you can clearly see 3 months ends on 17th August, 3 days of grace you have to add 20th August. But because the holiday is there all of a sudden, after the issue of promissory note, in the light of the provision section number 10, then you can see here that a due date will be on next day when office is open, that is 21st August 2021. Okay, very, very clear. That is your this answer. Finally, you have the answer in relation to interpretation of statutes. At the time of interpreting of a statute, what will be the effect of usage or customs and practices? Okay, so they have used this area, usage or customs and practices. They have said here, usage or custom and practice means what has been going on as a tradition. Okay, correct? Usage or practice developed under the statute is indicative of meaning recognized to its words by contemporary opinion. A uniform notorious practice continued under an old statute and inaction of the legislature to amend the same are important factors to show that a practice so followed was based on correct understanding of the law. When the usage or practice receives judicial or legislative approval, it gains additional weight. It has more value then. It will be considered more in the court of law. In this connection, we will have to bear in mind the two Latin maxims. What are the two maxims? Optima legium inter pares est constituted. The custom is the best interpreter of the law. And second is contemporanea exposito est optima et forticinia in lege. The best way to interpret a document is to read it as it would have been read when made. So when they had made, what was the thought process behind it? You have to think about that and then interpret the law. Therefore, they have said, therefore, the best interpretation or construction of a statute or any other document is that which has been made by contemporary authority. Simply stated, old statutes and documents should be interpreted as they would have been at the time when they were enacted or written. Okay. Then they have said contemporary official statements throwing light on the construction of a statute and statutory instruments made under it have been used as contemporanea exposito to interpret not only ancient but even recent statutes. Very clear, very simple, easy. And that's it, everyone. That completes our Inter Law amendments for December 2021 exam. I hope you enjoyed it. Wish you all the best. Take care. Study well.